Hello everyone and welcome to this question discussion session. I am JKP Singh. I am a faculty in Edge IAS, teaching Indian polity and public administration optional here. Uh, Friends, recently in the last week we have start of this civil services main examination, and we will be discussing right now the kind of questions that were asked to the students and aspirants in the Indian polity GS paper 2, particularly the polity aspect of the GS paper 2. uh, uh, there has been certain pattern. If we go into the question papers, we find certain patterns, and we'll be discussing it patterns also, and the kind of emphasis that this question paper intends to emphasize. Let's see how it goes. Indian polity, what we find that there are 10 marks questions and 5 questions have been asked, a total of 50 marks, and 15 mark questions, 4 questions were asked, total 60 marks. Out of 250, we find that 110 questions were asked from the Indian polity. So Indian polity within this GS paper 2 has more than is about 40% almost questions were asked. Let's see. If we go further into it, we find as these topics have been covered. I will discuss one by one. Let me make it very clear. There is reasons that UPSC asks questions on certain topics out of the entire syllabus. Why? We will be discussing. How? Again, we will discussing. What is the intent of the question papers? Basically, they want to see the general awareness of things happening around that is expected of a candidate aspiring to have a civil services career. So what is happening in and around, you have to have a eye and sensitivity to appreciate the issue and find a solution towards it. This is what you are expected to do after you are selected. It is part of the selection process. Therefore, UP wants to judge the kind of quality that you may have while you are studying, whether you have inculcated in yourself this kind of quality or not. Let's see how these questions is looking for these qualities in you. We find questions on judiciary. Quite large number of subtopics have been covered under the judiciary. The collegium system, the Supreme Court, construct of the collegium system. Then Supreme Court itself has coined the term constitutional morality and found it a sort of axis or fulcrum, as we call it, around which they expect the high functioning and even the citizens to work around this constitutional morality. This administrative tribunal offloading the mainstream judiciary, the legal judiciary, to offload their workload, and this attorney general supporting the system as the legal representative, the highest legal authority of Government of India. These topics have been in news in some way or the other, and covering and has been widely covered in the newspapers. So this judicial delays, we find large number of posts of judges have been filled these days through this mechanism. Therefore, this topic finds a place in the question paper because everyday newspapers are covering this. Even last week, 4 or 5 judges have been appointed by in the state high courts. So therefore, these questions were expected, and you are, as a candidate, you are expected to be very sensitive towards knowing the way of appointment, after appointment, how they function, whether they are working under the constitutional morality or not, sort of things. Again, the pardoning power of the president, the executive, from the executive side, they have asked the pardoning power of the, it's a regular question. And again, from the legislature part, we have seen the judiciary side of it and we have seen the executive part of it. Now coming back to the judicial legislative aspect, what we find is the amending power of parliament. In the 70s and 80s, there was quite a debate to what extent Parliament has the power. In the 70s, the Parliament, whether it can amend, to what extent it can amend, what is the jurisdiction of Article 368, the 24th Amendment, all sorts of things were then. Now it is a settled issue that Parliament can amend, provided certain that 73 all we know. We are not going into it. But what we are saying that Parliament power to amend should be proactive. When this large number of cases of some political issues of morality, even if there is no mention of whether a chief minister should function from a jail or how can he function, all sorts of things. So these were in the news for the last 6, 7, 8 months or a year or so. Therefore, this question was quite expected, and very recently, government, I mean, just 2-3 days back before that examination, government came with the 130th Amendment of the Constitution and amending the proposed amendment of the Article 75 of the Constitution. Therefore, this became a hot topic, and you are expected to be aware of such things. Again, federalism. The government's recent emphasis on financial discipline and debate on the kind of freebies, whether it is good, bad, that is not topic right now, but yes, it has been in debate recently. Therefore, within the federalism framework, they have asked questions on center-state financial relations. With, again, we have the new finance commission in place. So this again becomes a topic of current interest, and you are supposed to have that interest also. From the state side, we have a question on J&K reorganization. J&K elections recently held. Therefore, it was almost a certain questions. And electoral politics, again, this representation of People's Act 1951, the debate whether, to what extent, whether politicians, what are those unlawful activities indulged by the politicians or the chief minister or ministers, whatever. So therefore, this again was a question expected on RP. The learning point from this question, these question paper is, you should be aware of things happening around. Message for those who have yet to appear at the examination in 26, 27 is, keep your eyes and ears open, and you can expect at least 70% of the questions. And again, those who are yet to write the optionals, your optional too have certain relevance with the current things happening around. So you can reorient your focus on things that is happening around. So you expect questions on the things happening in and around. Let's see how these questions have been framed and how we should approach, or should have, some of us might have approached also, how to go about these questions papers. The very first question on RP Act, representation of, discuss the practice of representation of People's Act 951. Very important question. And what they have asked, you see there is a twist in the question. Analyze whether the increase in the asset of the legislature disproportionate constitute undue influence or not. There is a twist that whether amassing of wealth, whether it should be treated under anti-corruption acts or it should be treated under the representation of People's Act. This is the twist. So we are supposed to handle the question from the Representation of People's Act 1951 angle. So this is what these are: bribery, undue influence, appeal on grounds of religion, promotion of enmity, publication of false. These are the items which have been categorized as corrupt practices. And these corrupt practices really becomes corrupt when, look at this answer, when they are induced, when they are induced where they are induced to bribe voters or not. We have to see from that angle whether under the Representation of People's Act these unlawful practices are used to induce or bribe voters or not. If they are, then these the questions are. And then we have one ADR report, democratic report in 2004, which delineates certain facts and figures. 43% MPs face criminal cases, 29% of serious charges. These cases are important reference. This will strengthen your answers to the question. Again, the next question, as we have said, the administrative tribunal. Administrative tribunal, as we know, is a Indian Constitution. Originally, it was not in the Indian Constitution. As we know, Article 323A(b) introduced it in the Constitution by the 42nd Amendment Act. But basically, by a 1985 Act of Administrative Tribunal, the administrative tribunal were established. Administrative tribunals are basically to offload the mainstream judiciary, I mean the high courts and supreme courts, so that the administrative issues are handled by a judiciary and expert man of administrative proven merit. So these are the points which need to be discussed in the question, in the answer, and the need for administrative as compared to the court system here. But they have also asked to discuss whether the 2021 reforms, to what extent they are helpful. So 2021 reforms aims at, they have abolished 7 tribunals, as we know, and basically these are two, they were repetitive, sometimes repetitive in nature. So and financial burden also. So they have transferred the cases for to the high courts, mainly because when strict legal issues are involved, they can use it. Otherwise, by the tribunal. So we find, and we know, 2 kinds of tribunals. These are things discussed in the centralizing appointment through search cum selection committee is the most important reforms introduced in the 2021 amendment. So this kind of things are to be discussed in this, and there are some positive and there are certain positive and concerns which have to be discussed in the there are multiplicity of tribunals, streamlined administration, increased judicial scrutiny even by High Court, because the judgments, the orders of the CAT can be challenged in the High Court. Therefore, these are the positive trends, and there are still certain concerns about the specialized jurisdiction, and we can still, there is important Supreme Court judgment in 2021 about the judicial independence must be preserved and striking down the previous or tenure of executive dominance. Therefore, these points make the entire framework for answering this question. Next question, important question is, we are supposed to compare and contrast the pardoning power or of in India, President of India and USA. India and USA. This is the first question on the comparative constitutional mechanism that has been asked by the UPSC here. And what are there any limits to it in both the countries? What are the preemptive pardons? This is a typical USA concept. And it has been used in US, not very much used in USA, but this is important that we should know it also. So in India, the power is granted under Article 72. All these facts 72 article, and we have power of pardoning, reviewing, remitting, and commuting sentences. Applies mainly to death sentence in the court martial. This is important for Indian president, that it has been given this power also by the constitution. In USA, in comparison, Article 11 section 2 of the constitution gives this power, and what is important to them is the power is largely unfettered, can be exercised at the president's discretion, and judicial review is minimal. Two important contrasts. Indian president's power of pardoning is subject to judicial review. Number one. Number two, president's power can be exercised only on aid and advice of the Council of Ministers with the Prime Minister at its head. Therefore, in accordance with the rule of law, and subject to political advisories. And in USA, there is no judicial or legislative limits, and cannot pardon state crimes, because state is entirely different, occupies entirely different constitutional status in USA. So they have their own judicial system, not the Supreme Court of USA, not the President of USA, sorry. Now there is a concept of preemptive pardons. Preemptive pardons are to be exercised by the President of USA before any conviction. This is a unique power to the President of USA, and they exercise the power. हालांकि बहुत ज़्यादा ये नहीं करते हैं, but this practice unprecedented and controversial in India, and where pardons follow. हमारे यहाँ legal conviction के बाद President exercises this kind of power. In USA, it is different. Therefore, we find that both India and USA empower their president, and clemency power has been given to the presidents of the two countries, but their exercise is entirely different. Next question is about the nature of Jammu and Kashmir Legislative Assembly after Jammu and Kashmir Reorganization Act 2019. Briefly describe the powers and functions of the Assembly of the Union Territory of Jammu and Kashmir. Answer in Unford. We all know Jammu and Kashmir enjoyed a different status, special status, Article 370, 2019, done away with, and we have a separate J&K Legislative Assembly reorganization. Reorganization Act 2019, and under this we have two different union territories, that is, and Ladakh without one, and Jammu and Kashmir has been given a state legislative assembly since the very recently elections took place, and it was sort of triumph of democracy, as it has been said. Therefore, the question was almost expected, and these are the powers: state list and concurrent list. There is, we have dealt it a bit lengthy in a sense that we are supposed to discuss the Jammu and Kashmir post 19 with Delhi and a full state, how they can be compared, and how just to put the J&K as a union territory into a proper perspective. So this gives a holistic view and position the J&K union territory in a proper perspective. So these are the kind of type powers, and this is all illustrative. You are supposed to know it. Now the Attorney General of India, crucial role guiding legal framework of the union government and ensuring sound governance through legal counsel. Again, we all know Attorney General of India, highest legal law officer, when in the 50s and 60s, early 60s and late 50s, there was a movement that let Attorney General, which is still a constitutional authority, should be placed under the Ministry of Law, but it was not. It was mooted, but not didn't see the day of the light of the day, and therefore we still have Attorney General of India. He is the only functionary who is still not part of or member of the parliament and can enter and discuss, though not he cannot vote. So we are supposed to discuss his crucial role. What makes Attorney General important and occupies a vital place? Recently, large number of cases, whether SIR case or other cases, Attorney General has been representing Government of India and the Union Government. Therefore, it has come to notice of all, and it becomes a hot topic for discussion. Attorney General of India, Article 76, Part 5, in the Union Government list. But since his role as a legal advisory, therefore I have classified it in, for our purposes, discussion purposes only, in the judiciary part of it, and therefore we find a question on Attorney General also. We all know what are his rights, how he governs, and what is the limitation. Came into focus because of his large presence in the Supreme Court and almost all cases winning for the Union Government. Attorney General is ably assisted by the Solicitor Generals, but we can just make a reference of it, not required. And he is our new R. Venkataramani, who is and there is no, I mean, his powers, his functions, there is no proper procedure for his appointment. He occupies only, he is appointed and enjoys power during the pleasure of the president. This is what exactly is written in the constitution. So it's a unique thing. Normally when a government changes, Attorney General also resigns on his own, because again, it's a constitutional morality, as we have said, and Supreme Court also asking that every high functionaries, including citizens, are supposed to work under the constitutional morality norms. Now coming to, this is how I made the background of constitutional morality. Constitutional morality is something related to ethics, values, not defined, cannot be probably defined, changes with changes in circumstances. Supreme Court finds that yes, entire democracy functions on certain moral values, because democracy itself is a value. It is a structure. A structure is structured to in pursuance of certain values. And one value in India can be different from values of USA or for that matter UK. So constitutional morality is, there are certain universal morality also, but politically saying it's a state country specific. To that extent, we are supposed to adhere to the constitutional morality, and it is essential check upon the high functionaries and citizens alike. This is important, and Supreme Court itself has propounded it. And the question says that a concept of constitutional application of boundaries between judicial independence and judicial accountability पर भी ये लागू होना चाहिए. It means that our question framers also had a thinking that let the aspirants of civil servants also know the functioning of the judiciary. Hence this question. So it's again Ambedkar's opinion we have mentioned, and judicial independence, how judiciary can be functions independently. There are certain inherent structure in the constitution, mechanism, that apart, that we have discussed. But that apart, our constitutional morality, rule of law, transparency, integrity, and democratic ethos, these are the basic axis on which the independence of judiciary revolves. But at the same time, the judicial accountability is also supposed to be in place. They are supposed to be responsible to the democratic values, to the citizens of the country. Delays, maybe certain, on many occasions, the discussion about the moral values, these are the things which needs to be discussed in the judicially independence and versus judicial accountability debate. And Article 224, 147, Supreme Court, and we all these know. Applications are basically at these stages that these values are to be applied in the appointment, judicial conduct, judicial review, and public trust is very important. Normally, you find these things in any places. Our value addition is the introduction of the concept of public trust. So, since morality is a subject which can be legitimized only by the public's trust, therefore, this becomes an important value system in the discussion of this answer. So we have concluded that ensures judiciary remains independent, at the same time it is answerable and accountable to itself also, and accountable to the country, democratic ethos, and the systems are values, transparency, integrity, all sorts of things. Next question is, Indian Constitution conferred the amending power of ordinary legislative institutions with a few procedural hurdles. The question framer has called it hurdle. Still, it is part of the procedure. Hurdle does not mean deliberate, designed obstacle not to go ahead with the amending powers. But at the same time, it acts like a check. This hurdle is like a check. So, we are supposed to discuss it, how the different special majority requirement, state ratification, presidential assent, no joint sitting, and initial restriction, these allows bill to be deliberated. It allows to have the larger public and representative participation in amending of the, depending on the importance of the bill, we have these special majority. We have certain normal majority cases also, and we have certain special majority requirement also, as far as not only amending but any bill passing in the, but as far as amendment is concerned, we are supposed to look at this special majority requirement, and this acts definitely as a sort of obstacle or deterrent or a certain space for more discussion, for larger public opinion mobilization, etc., etc. And there are procedural limitations and there are some substantial limitations also. Two kinds of limitations. One is basic, all we know, 73 Supreme Court saying you cannot change the basic structure. Basic structure is what I will decide, and I will let you know what is the basic structure from time to time, case to case basis. At least 20-25 numbers of basic structures has been identified and here marked by the Supreme Court itself. So some of them we have supremacy of the Constitution. These are the things. The legislature cannot amend the Constitution to the extent it infringes the basic structure of the Constitution. Again, there are judicial safeguard, power of judicial review. All we know, Supreme Court can always review the amending powers and the amended bills. Democratic principles, these are all public mobilization and opinion expressed in the parliament. There are temporal checks of frequent amendments, ensuring responsive exercise. These are the sort of restriction on parliament, some substantive, some procedural, and we are to discuss each in these format. 5 important procedural limitations, 4 substantive limitations. But these are obstacles only to ensure that genuine amendments in the interest of the public, in the interest of the democratic ethos, there are certain barriers, judicial review, majority. If you cross it, these are the litmus test, I would call it. And if you are able to go through it and finally able to get the bill through the parliament, then it is supposed that this amendment is all right. And therefore, we have made our constitution, not only there are certain obstacles, we have make it responsible, we have make it responsive. It is not that we have not given parliament power to amend the constitution, to make it more dynamic, inviolable, and responsive to the needs of the society. So these are the ways through it. Parliament can amend the constitution, but passing through certain rigorous litmus test. Evolution of collegium system, critically examine the advantage, disadvantages of the system appointment, Supreme Court in India, and we are supposed to compare it with the system of USA. We have written like this in the two different boxes. We have compared it, and we also have made reference to 3 judges cases that we all know, 82, 93, 98. NJAC, Supreme Court doesn't agree, then the collegium system, then the executive or the government requesting it to have a review of it. Then finally, the issue settled in the favor of collegium system, which even continues till date. However, the last appointment has to be done by the executive with the recommendation of the Prime Minister by the President of India. Here in USA, what is important? USA is very important. Here the power lies with the President, though Senate provides advisory and consent through confirmation nearing, but it is almost the President who has the last laugh mostly. That collegium system continues, and President nomination and Senate confirmation. In India, we don't require confirmation from the Parliament. Therefore, these are the advantages, these are the disadvantages. Also, there are certain, every norm, every procedure has certain limitations. So we have also discussed in length, concluding that yes, our democratic participation and transparency are the hallmark. Therefore, our system seems to be suitable to our conditions where more transparency is required. So, and out of the 9 questions that we had on Indian polity, we have the question on center-state financial relations in the context of planned development in India, or how it has impacted the fiscal federalism in India. So we have seen the kind of finance commission we all know, 280 article, the planning commission 250 2014, the planning commission existed. It was not a it was not a body, it was an executive made body. So it was replaced by the Niti Aayog recently in 2014. Then we had a important guard formula 69, how to rationalize the plan transfer from the center to states. And the 11th, 12th rounds, now we have the 15th Finance Commission reports with us. Therefore, all these things impact our fiscal and financial relation between a state. This question has been asked mainly because I perceive that Prime Minister also said from on 15th of August that yes, by Diwali we are going to have a large scale pro-people GST amendments. Therefore, this question, once you have seen that Prime Minister's speech, so this question in one way or the other was in the offing, almost get crashed into the question paper. So we have this recent reforms and impact of this 14th Finance Commission, 15th का नीति आयोग, GST 2017, and COVID had of course the impact on the fiscal relationship. So next year also we expect, because of almost certain GST reforms pre-Diwali season, central state financial lessons have been shifted. Therefore, these are 9 questions, important questions. I would say 7 out of the 9 questions were almost guessed. 2, yes, president power was a normal question, but other questions were ऑलमोस्ट अकरेंट, बिल्कुल लग रहा था जैसे आसपास ये हो रहा है, और आपसे उम्मीद की जाती है कि इस तरह के क्वेश्चंस के प्रति आप न केवल संवेदनशील रहेंगे बल्कि आप इस क्वेश्चन की भरपूर तैयारी करेंगे, और आपसे ये उम्मीद की जाती है, देयरफॉर ये क्वेश्चन आया है. यही पैटर्न मेरे ख्याल से 26, 27 में भी होने वाला है. तो देयरफॉर मेरी भविष्यवाणी तो मैं नहीं कहूँगा, लेकिन मेरा गस वर्क जरूर ये है कि keep alive to the happenings around, through the newspapers, through the media, through friends, through discussion, and of course we are here to make you more sensitive. Take advantage of the situation. We will also give you input. We all together can make our future bright. Thank you very much.